guide you through, they see you through, right? They provide necessary advice that you need. Once you approach them, they guide you, they discuss with you honestly. I think this is what will benefit you more. You understand? Based on our experience in this organization, we have been dealing with issues, and I think that this will benefit you more. You understand? So they advise you, advisory opinions. That's what I'm talking about. Some institutions may offer advisory opinions on procedural issues or on the applicability of certain rules, helping parties make informed decisions. You understand? So that's what they do. Then we'll talk about facilitation on multi-party and multi-contract arbitration. Multi-party and multi-contract arbitration. Complex disputes. Institutions have developed procedures to efficiently handle multi-party and multi-contract arbitrations, which are increasingly common in international disputes. You understand? They facilitate coordination among multi parties and streamline the arbitration process. So that's what they do. Support for development, for developing jurisdiction. Support for what? Developing jurisdiction. That is support for third world countries or developing nations. You understand? Or those that are coming, they are yet to develop their arbitration procedures to a standard. They can support them. You understand? So building capacity. Institutions often engage in initiatives to build capacity in developing jurisdiction, providing training resources and support to local arbitrators and practitioners. That's what they do. Promotion of local arbitration by encouraging the establishment of local arbitration centers and promoting awareness of arbitration in emerging markets. Institutions contribute to the growth of international arbitration practices globally. So these institutions are playing vital roles to make sure that upcoming arbitration centers are also being developed, they are being guided, they are being, supported and empowered. That's what it means. Do you understand? So doing, the message on arbitration is going on. Then research and development, policy papers and reports. All right, institutions conduct research and publish policy papers that address current trends, challenges, and innovations. All right, in international arbitration. So this is what they are doing. Then collaboration with academic institutions. Many institutions collaborate with universities and think tanks to promote research, enhance legal scholarships, and support evidence-based policy making in arbitration. So this is what these institutions are doing. So they are not just there providing only standardized rules to be followed, but they also support, they encourage, they also partner, they conduct research. Do you understand? And all of these are being done by this institution. I don't know whether you are following me. I hope you are following me, right? So you are following me, right? So you are following me, please. One, if you are not following us, or if you have not subscribed to our YouTube channel, or you have not followed us on our Facebook account, do follow us because these are the criteria for you to receive this certificate. Tomorrow, those of you that are participating in today's training, I'm going to mark your names. I'll mark it and then share with you. I'll snap it and share in our WhatsApp group so that you see that this things we are very serious about it. Right? We cannot have 200 people writing exams. No, we have not had 200 people join the meeting. No, it's not possible. You understand? We are going to be very, very serious about it. We are not going to send the link for examination in the group again. We'll send to individuals that have been committed, that will know them. That's what we're going to do. So let me go ahead and take the last part of today's training. We're going to look at recognition and enforcement of international arbitration awards. Recognitions and enforcement of international arbitration award. The recognition and enforcement of international arbitration award is governed primarily by the New York Convention on the recognition and enforcement of foreign arbitral awards adopted in 1958, and that has been in existence out to today. You understand? So many awards are being enforced based on the provisions of this convention. Do you understand? So what are the key principles here? International frameworks. The New York Convention provides a framework for countries to recognize and enforce arbitral awards made in other countries, promoting international trade and investment. Right? So it doesn't matter where such arbitration is being done, such an award is being given. What matters is that there is a provisions for you to enforce it. So you enforce it. Do you understand? And the New York Convention provides that. And the New York Convention is a convention of the United Nations, which most members of nations are members of the UN. Do you understand? Member states are members of the UN. So recognition, this refers to the acknowledgement that an arbitral award is valid and enforceable. Awards must typically meet the requirements set out in the convention and the domestic laws of the enforcing states. Do you understand? So if it's Nigeria that has to enforce, the award must make provision in such a way that the laws of Nigeria favors the enforcement of that award. Apart from the fact that you are going to use the New York Convention provisions, you still make sure that the awards are compliant with the Nigerian laws, for instance, for it to be enforced. You understand? Otherwise, you come here, it becomes so difficult to enforce such. Enforcement, this is the actual process of compelling, that you are defining enforcement. This is the actual process of compelling compliance with an arbitral award through judicial means. That is, after you receive your award, go to court, make sure that it's being enforced. Do you understand? So a party seeking enforcement must present the award to a competent court in the jurisdiction where enforcement is sought. You understand? And then the court will acknowledge it and validate it and then enforce it. Requirements for enforcement. Requirement for enforcement. To enforce an international arbitration award under the New York Convention, the following conditions must be met. 1. Written agreement. There must be a valid arbitration agreement in writing. We said that yesterday. You must have a written agreement. Award must be final. The award must be final and binding, meaning it has resolved the dispute between the parties. Do you understand? So the dispute must be resolved. It's not an open case. Do you understand? It must be final. So recognition of jurisdiction. The parties to the arbitration must be from countries that are signatories to the New York Convention. Do you get it? The parties to the arbitration must be from countries that are signatories to the New York World Convention. So it can be made easy to be implemented. Once they are member states and they have signed to this convention, it's going to be easy to enforce. Steps for enforcement. What are the steps for enforcement? Filing a petition. The party seeking enforcement must file a petition in the appropriate court. You understand? So once you receive your award, come here to Nigeria, you approach a court, file a petition to enforce your award that you have received based on the outcome of the arbitration. Do you understand? Then providing documentation. The petitioner must submit the original award and the arbitration agreement along with translations if necessary. That's in case what was done in Arabs. Then you must have both Arab and the English translations in. All of this you tender it to the courts. Do you understand? Court proceedings. That is, I'm talking about Arabic rather. So court proceedings. The court will review the petition and may hold hearings to assess whether the award meets the enforcement criteria. That's why we say that whatever award being awarded must have the basis upon which the laws of the land can, accommodate and easily enforce. So, and this is what we are having a review here: court proceedings. Judgment. If the court finds in favor of enforcement, it will issue an order recognizing and enforcing the award. That's it. So what are the enforcement mechanisms we have available? What are those mechanisms you can use to enforce your award? One is national courts. We have the national court. Enforcement is sought through national court, which have the authority to recognize and enforce award per local laws and international treaties. Where there are international treaties available, it can be used. Also, it can use domestic laws to enforce such awards, so far as the countries concerned are members of, are signatories to the New York Convention. Do you understand? Then we have what we call the exporter. The exporter also is one way or one mechanism we can enforce. This has to do with some jurisdiction that may require a procedure called exporter, where a local court formally recognizes the foreign arbitral award before it can be enforced. Do you understand? The court must first and foremost recognize it formally, an award, an international or a foreign award, arbitral award, before it can be implemented and enforced. Then we have what we call the reciprocity. The reciprocity, that is, some countries may enforce foreign award based on the principles of reciprocity, meaning they will only enforce awards from countries that provide similar treatment to their own awards. That is, when it was my own time, you enforce it. So now that it comes from you, I will also do same to you. All right. That is, every good gesture deserves another good gesture. That's what it means, right? So reciprocal exchanges. Do you understand? Then grounds for refusal of enforcement. What can make an award not to be enforced? Are there chances that an award may be refused for enforcement? Let's look at such. Enforcement can only be refused on limited grounds as outlined in Article 5 of the Convention, such as lack of what? Proper notice of the arbitration proceeding. Lack of what? Proper notice of arbitration proceeding. That's number one. Number two, award exceeding the scope of the arbitration agreement. Any award that exceeds the scope of the arbitration agreement can also not be enforced. Then, non-arbitrability of the subject matter under the law of the enforcing state. That is, the matter which you are talking about now is not under, cannot be admitted in arbitration. The matter is beyond arbitration. It's not arbitrable. Do you understand? It can only go to a formal law. So once you go to arbitration and you bring an award, they will tell you that this, in Nigeria, for instance, now, this matter is not under, it cannot be adjudicated in an arbitration tribunal. Do you understand? It has to be in a formal court of law. So in that kind of situation, it cannot be implemented, cannot be enforced. Then, invalidity under local laws. That is, if the arbitration agreement is deemed invalid under local laws of the country where the award was made, enforcement may be denied. The incapacity, that is, if one of the parties lack the capacity to enter into the arbitration agreement, this may serve as a ground for refusal, maybe underage, or maybe somebody insane, or anything like that. It can then, or maybe someone that is not a citizen in that particular jurisdiction it becomes so difficult to enforce. Then public policy. Enforcement may be denied if the award is contrary to the fundamental principles of the law of the enforcing state, often refers to as order public. Do you understand? Order public. Then we'll talk about procedural impropriety. Procedural what? Impropriety. This can also affect the implementation or enforcement of an award. If the arbitration procedure did not comply with the agreed rules or standards of fairness, this may lead to a refusal. You understand? So let's look at some of the challenges in enforcement. We'll discuss some of them, but we'll still discuss varying standards. Challenges in enforcement, varying standards. Different jurisdictions may interpret the ground for refusal differently, leading to inconsistencies in enforcement. This is a challenge. Then political risk. In some countries, political consideration may affect the willingness of courts to enforce foreign awards, particularly in politically sensitive cases. Do you understand? It may be very, very challenging to enforce an award. Delays. Enforcement proceedings can be delayed due to complex legal processes, leading to increased cost and uncertainty for the parties in the matter. So these are some of the challenges that you can see when it comes to enforcement of an award. Let's look at trends and development. Trends and development. Trends and what? Development. Growth of arbitration. The increasing globalization of trade has led to a rise in international arbitration, making the enforcement of awards more critical. You understand? So globalization has also helped to spread the message of arbitration and then causing it to grow. Do you understand? Because of international trade. International trade is a trade that cut across national boundaries. So arbitration follows it because arbitration takes place in international trades and investment. Do you understand? Basically. So technological advancement, the use of technology in arbitration such as virtual hearings is becoming more common, which may influence how awards are enforced. Do you understand? Judicial cooperation. There is a growing trend towards judicial cooperation among countries to facilitate the enforcement of arbitral awards. So these are the issues. So what we are saying in essence is that the recognition and the enforcement of international arbitration awards are crucial for ensuring that parties can rely on arbitration as a means of resolving disputes. The New York Convention plays a pivotal role in facilitating this process, promoting legal certainty and stability in international commercial relations. So this is what it means. So you can go and arbitrate your matter without being afraid anywhere. You can enter into a business transaction so far as you know what you are doing and you sign the right contract, citing different causes of arbitration and citing which one you can use when the needs arise, then you are good to go. Do you understand? So this is the much we can cover today. I think we will stop here today. Tomorrow, we are going to step into module 4. We'll still have a long way to go before the month's end. We still have a long way to go. Module 4, we'll start module 4 tomorrow. And I think module 4 has more than 5 units. All right, and we are going to look at it all. And then module 5, 6, 7, 8, as the case may be. So, but thank you very much for taking time to be part of today's training. We hope to see you tomorrow as you invite someone to also take part in the training. Thank you and have a wonderful night rest. I hope I don't have questions here. Let me just run through your comment section in case I'll see a question that I can answer and may be able to respond. Or in case there are no questions, for those of you that will be inducted in Lagos tomorrow, congratulations in advance. Those of you to be inducted in Lagos tomorrow, congratulations in advance. I will wish you a happy induction. Thank you very much and have a wonderful night rest. Bye from our side here. Thank you.